Today I want to talk about living trusts and specifically the biggest problem I see with trusts. This is usually that they are not funded, and it often happens with trusts that people have done themselves or to some extent trusts that attorneys have prepared but not funded. So what do we mean by the funding process? Well, that is living trust lawyer speak for putting your assets into the trust. Once you've done a trust, even if you've attached a list of your assets to that trust, it's still not complete. What it does need to avoid the court probate process is actually changing title on most of what you own. It also might mean changing beneficiary designations, and we'll talk about that too. But the main thing is things like real estate, bank accounts, investment accounts, anything that has any value really, typically something over roughly $30,000 or $40,000, should be transferred into the trust. And what that means is, say for real estate, making a new deed and recording it with a county recorder where that property is, to put that property into the trust. And the deed will read your name as trustee of your trust. Likewise for things like investment accounts, other things, bank accounts, CDs, anything that again has some value should read your name as trustee of your trust and not just your name individually. Otherwise, that means it's probably going to go through probate, and that's what we're trying to avoid with the trust. If you've also got young children and there are things like life insurance or retirement accounts, you don't want to have their names on it directly. That means if they're under 18, a guardianship would have to be established, and it'd be kind of expensive, and also means they'd get whatever's in that guardianship right at age 18, which is probably not a great idea. And so most of the time we recommend that our clients have at least the contingent or alternate beneficiary be the trust instead of someone individually. We do that for our clients. Most attorneys don't. They might go so far as changing title on your real estate, but there are very few who actually then move on to change things like bank accounts, investment accounts, things like that. But we take care of that and take you through the process because we've seen that when it's not done, it's going to cost the family a lot more money in probate fees and attorney fees if it's not done. So if you've already done a trust, check your trust and check the assets. Make sure that assets are titled in the trust name, and check every few years. If you've bought probably a new house or investment property, changed investment advisors, things like that, that may mean that assets are no longer in the trust and they need to be. And then at very worst, be sure that if you've got a trust, you've got some backup measures in place to at least avoid the full probate process. We do that for our clients as well. One thing is the trust schedule of assets, where all of your assets are listed. It does not have to be something as descriptive as an account number, but at the very least, having a list of where assets are, what institutions they're at, a list of property addresses for things that you have, and this can be updated every few years and should be. Something else that we do that I've not seen a lot of is called a declaration of trust, saying that you want everything that you have to be part of the trust. These things will come in handy if, at worst, something is not titled in the trust name at death. We can use that to shortcut the probate process and save some time and money and get those things in the trust where they should be. So if you've done a trust, ask your attorney, is everything in the trust that it needs to be? If you've done one, do it yourself. I'd say have an attorney check it out. That's something we're happy to do. We're also happy to help with funding if you've already got a trust and need to make sure things are in it.